going to start a new subject which is called products liability. It's also torts. But before we start products liability, I want you to make a note as we talked about negligence. And I want you to make a note as to defenses of negligence. They're in your book. So please read. The first defense to negligence is called assumption of the risk. So if you do something that you know is dangerous and you're harmed, then you can't sue. The next defense to negligence is called contributory negligence. And contributory negligence is where you contribute to your own harm or injury. Your award can be reduced by how much you contributed. The third defense to negligence is called comparative negligence, where they compare your contribution to your harm and the other side. And if yours is greater than the other side, you can't collect. You should note that in New York, we do not have comparative negligence. In New York, the defenses to negligence are assumption of the risk and contributory negligence. Our next tort is called products liability. What is product liability? Well, product liability is strict liability with products. It deals with product liability is the liability of manufacturers, sellers, and others for the injuries caused by defective products. Negligence in product liability requires the defendant to be at fault for causing the plaintiff's injuries. A tort related to defective products in which the defendant has breached the duty of care, remember our elements of negligence, and caused harm to another. In other words, the plaintiff must prove that the defendant was at fault for causing his or her injuries. Negligence remains a viable but sometimes difficult theory on which to base a product's liability action, because you have to prove who in the chain was negligent. Product liability, one is called misrepresentation, and it has to be intentional, mens rea. Intentional misrepresentation is called fraud, and it's a tort in which a seller or lessor fraudulently misrepresents the quality of a product or conceals a defect in the product, and a buyer winds up being injured. Because most manufacturers, especially the respectable ones and sellers, do not intentionally misrepresent the quality of their product, fraud is not too often found in these cases or the basis for product liability actions. Now, product liability and strict liability. This is important. Let's look at strict liability. It's a doctrine that makes manufacturers, distributors, wholesalers, retailers, and other in the chain of distribution of a defective product liable for the damages caused by the defective product, irrespective of fault. So if you know something is dangerous and you sell it anyway, I don't have to prove it was dangerous because you are responsible. Strict liability. Now, strict liability only applies to products, not services. Make sure you understand that. Strict liability only applies. Now, we talked about the chain of distribution. All manufacturers, distributors, wholesalers, retailers, and subcomponent manufacturers are always involved in a transaction. If you buy a product, you buy it from a retailer. The retailer gets it from a distributor. The distributor gets it from the manufacturer. That's the chain. And in that chain, all are responsible and all are subject to money damages. Now, one of the problems with product liability is that it's also a consumer issue. In other words, when we buy something, we need to feel that what we're buying is safe, that there's no danger to us. And so when we look at product liability, we look at a number of things. The first thing we look at is product defect. Product defect, again, is something wrong, inadequate, or improper in the manufacture, design, packaging, warning, or instructions about a product. The injured party must show that the product that caused the injury was somehow defective. Excuse me. And does not have to prove who caused the product to become defective. Defect in manufacturers. A defect occurs when the manufacturer fails to properly assemble a product, properly test the product, or adequately check the quality of the product. The next thing that can cause a product is defect in design. And a defect occurs when a product is improperly designed. Back in the 60s and 70s, one of the problems with automobiles were that they were improperly designed. And because of it, it resulted in injuries and harm. That's why we have what is called the crashworthiness doctrine. And it's a doctrine that says that automobile manufacturers are under a duty to design an automobile so that they take into the account the possibility of harm from a person's body striking something inside the automobile, or in the case of a car accident. Failure to warn. This is why if you buy a product, you'll see a lot of times a label. Usually you can't read it, but it's designed to meet to overcome the failure to warn. And a failure to warn is a defect that occurs when a manufacturer does not place a warning on the packaging of products that could cause harm or danger to a person. Manufacturers and sellers owe a duty to warn consumers, you and I, about the dangers of using these products. A proper and conspicuous warning placed on the product insulates or saves the manufacturer and others in the chain of distribution from strict liability. In other words, if they warn you that a product is dangerous and you use it a certain way, and you use it that way after they warned you, then you can't sue. Defect in packaging. And defect in packaging is a failure that occurs when a product has been placed in packaging that is insufficiently tamper-proof. Years ago, we had a number of cases where people would go into stores and intentionally sabotage products. There was one case where a man was taking a needle and putting poison in products that were on the shelf. Because of that, as you notice, almost all products are wrapped very well. You spend a lot of time just getting the product out of the packaging, and that's to prevent tampering with the product. And the other defects that we need to know is failure to provide adequate instruction. And that's a defect that occurs when the manufacturer does not provide detailed directions for the safe assembly and use of a product. Now, so we know what product liability is, the different elements. Let's take down the defenses to product liability. The first defense is generally known dangers. This is a defense which acknowledges that certain products are inherently dangerous and are known by the general population to be so. So if you use it and you know that it's generally dangerous, then you bear sole responsibility. There's another defense to product liability. It's called the government contractor defense. And it's a defense which provides that contractors manufacture products to government specifications, and if they do so, they are not liable if the product causes injury, because they only followed the government's instructions. Another defense is abnormal misuse. That's when somebody uses a product not in the manner that it was intended to be used. We see this about the fact that somebody suggested, I think you know who, that we shoot in our arms disinfectant to so-called kill the virus. That's abnormal. And as you know, some people believed it, and some of them have died or suffered serious injury. The next thing as a defense is called a supervening event. Now, the word supervening means superior intervention. We will talk about this again, supervening. And that's when the product is alterated or modified by a party who is not involved in the chain of distribution. That's when you get a product and you alter it to be something that it was not intended to be. As you probably read in your book, another defense is statute of limitations. And you should know that, of course, that a statute of limitation requires you to do certain things by a certain time, or you lose the right to do it. And of course, the other defenses to product liability is contributory negligence, which we explained to you earlier, and comparative negligence. And as you know, contributory negligence says that a person who's injured by a defective product but has been negligent and has contributed to his or her injuries can only recover that part which they did not contribute to. Comparative negligence, which we discussed earlier, is in your book and does not apply in the state of New York. I encourage you to read the chapters on negligence, gross negligence, product liability, and intentional torts. Please study these. These are important. They're everyday incidents where the law affects our lives. We will see you next video.